Section 89 ADR Arbitration and Conciliation Act. Supreme Court said the following. 1. Summary of Section 89 is: know the dispute. What are the duties of the court? Know the dispute. 2. Exclude unfit cases which are not arbitrable. 3. Ascertain the consent for arbitration or conciliation. If there is no consent, then select Lok Adalat for simple cases and mediation for all other cases. Reserve reference to a judge-assisted settlement only in exceptional or special cases. So, the court may, now another thing is formulation under 89, Section 89, settlement of disputes outside the court. Number 1, where it appears to the court that there exists elements of a settlement which may be acceptable to the parties, the court shall formulate the terms of settlement and give them to the parties for their observations, and after receiving the observations of the parties, the court may reformulate the terms of a possible settlement and refer the same for arbitration, conciliation and judicial settlement, including Lok Adalat. D. Mediation. Where a dispute has been referred, A. for arbitration or conciliation, the provisions of ACA shall apply as if the proceedings for arbitration or conciliation were referred for settlement and the provisions of the ACA Act under the ACA Act. B. If it is to Lok Adalat, the court shall refer the same to Lok Adalat as per Clause 20, Subclause 1 of Legal Service Authority Act 1987. If it is for a judicial settlement and a court judge-assisted settlement, the court shall refer the same to a suitable institution or a person, and such person or entity shall be deemed to be a Lok Adalat under Legal Services Authority Act 1987. And for mediation, the court shall effect a compromise between the parties and shall follow such procedure as may be prescribed. Order 10 details. Order 10 Rule 1A. Order 10 Rule 1A is direction of the court to opt for any one mode of ADR. After recording the admissions and denials, the court shall direct the parties to the suit to opt either mode of settlement outside the court as specified in 89 Clause 1. On the option of the parties, the court shall fix the date of appearance before the some forum or authority may be opted for by the parties. Order 10 Rule 1B. Parties to appear before ADR forum. Order 10 Rule 1C. Appear in court if ADR efforts fail. Presiding officer of ADR forum is satisfied that it would not be proper in the interest of justice to proceed with the matter further under ADR, then it shall refer the matter again to the court and direct parties to appear before the court. So this is it regarding ADR. Now some other small questions about ADR. Arbitration is binding. Order, award. In conciliation, it is a non-binding. It has to be a settlement. An award is a judgment given by the arbitrator. Next. How is the arbitrator appointed? 1. By agreement of parties and by court under 89. Duties of conciliator. To assist the parties to reach an amicable settlement, to maintain confidentiality. And family court case includes marriage, divorce, adoption, maintenance, custody and guardianship. For this, you will use one of the ADRs. Conciliation mostly. Law relating to maintenance, Section 125 CRPC and Hindu Marriage Act and HAMA. Procedure for arbitrator. No CPC, no IEA, only natural justice and audi alteram partem. Can a partition suit be filed by a lady? Yes, after 2005 Amendment of Succession Act. Who will pay remuneration to the arbitrator and the parties? Does ADR affect the lawyers? No. They represent the parties in arbitration tribunal. Advantages of ADR. Expensive, rich man, justice, fast and flexible. ADR is alternative dispute resolution or external dispute resolution. Campaigner for ADR is ICADR, is USA. Now, in India, first one institution is ICADR, International Center for ADR in Delhi. Now we have one in Bombay also. Areas where ADR work is consumer protection, family matters and business, private and international law, and MACT. ADR, a technique for dispute resolution through the intervention of a third party whose decision is not binding legally on the parties, aims at providing a remedy most suited to both the parties. Now, statutory recognition of ADR, which are all the sections. 1. CPC, Order 32A, Rule 3. Then Order 10, 1A, 1B, 1C. Read with Section 89 CPC 1989. Next, Industrial Dispute Act, Section 12 refers to conciliation, the industrial disputes. In Hindu Marriage Act, Section 23 regarding reconciliation. Family Courts Act 1984, matrimonial disputes through conciliation and counseling. Arbitration and Conciliation Act, Unicitral model is adopted. Conciliation is used in MACT cases. How do matters come before the Lok Adalat? Court will refer pending cases to Lok Adalat. Constitutional background for ADR. Free legal aid to indigent persons, Article 39A. Right to life, Article 21, including faster justice. V.R. Krishna Iyer and Bhagavati report suggested ADRs. CILAS, their committee was Committee for Implementation of Legal Aid Services, CILAS, SILAS. Modes of ADR. What are different types of modes of ADR? Arbitration, conciliation, mediation, negotiation, counseling, expert appraisal, mini trial or a case presentation, which is a non-binding process, and hybrid arbitration, that is ARB-MED, ARB-MED-CON-ARB. Fast track arbitration, time bound arbitration. For national and international arbitrations for commercial disputes, the arbitration concludes within a short period, 1 or 2 days or even 1 or 2 months, depending on the size of the case. Lok Adalat formed under Legal Services Authority Act 1987. ODR, online dispute resolution, is now also virtual courts. They are now going on, where the accused person is presented in the court from a PS through a video link, who will decide the matter in Lok Adalat, sitting judge, president, and help of the bar. Definition of arbitration: a settlement of differences and disputes by mutual understanding or agreement by parties, where the rights and liabilities of parties are adjudicated, which are binding on them. Such settlement is made before the arbitration tribunal, but not by a court of the land. Difference between arbitration and court of adjudication. In arbitration, disputes are matters where high technicality or expertise is concerned. Experts in that area can be appointed, where judges are lay people technically. In court adjudication, contractual rights of parties are determined strictly as per the document, whereas in arbitration, the arbitration can modify the contractual rights of the parties at its discretion with the consent of the parties. Matters which cannot be referred to arbitration, they are insolvency proceedings, then industrial disputes and probate proceedings, and matrimonial cases, that guardianship appointment except terms of divorce. An appointment of arbitration is Section 11 of ACA Act. Appointment of arbitration is Section 11 ACA Act. Number of arbitrators is as per Section 10. Then challenge and removal are from Section 12 to 15. Challenge and removal Section 12 to 15. Place and venue of arbitration is Section 20. Comfort of the parties. Commencement of the arbitration proceedings as per Section 21. Settlement through negotiation, mediation, conciliation while arbitration is pending is permitted. Form of content of the arbitral award is as per Section 31. Termination of arbitration is Section 32. Apply for set aside award is Section 34. For appeal lies from arbitration. Yes, in 2 cases according to Section 37. That is lack of jurisdiction. Second, dispute beyond the scope of arbitration authority. And what is conciliation? A method used by parties to dispose dispute to reach an amicable settlement with assistance of an independent third person is institution. Statutory recognition of conciliation. Industrial Dispute Act 1947, Hindu Marriage Act 1955, Family Courts Act 1989, CPC 1908, amended 76/99 in 2002, Legal Service Authority Act 1987, Arbitration Conciliation Act 1996, MACT claims. Not famous cases in ADR. Salem Bar Association case, where the ADR rules made under CPC can be applied to supplement the cover under Family Courts Act as far as the conciliation or mediation is concerned. The court annexed the proceedings of ADR was incorporated in CPC for first time in India in 1999 and 2002, which reaction was reinstated by CPC in 1999-2002. Section 89, which Section 89 was reinstated, provided for authority of the court to try the process of ADR. Significance of the case: Salem Bar Association versus Union of India. The Supreme Court asked the High Courts to approve the rules made by Justice Jagannath Rao Committee and implement ADR measures under Section 89 of CPC. First Lok Adalat were organized in 1982 in Gujarat, 1985 in AP. Cognizance of cover by Lok Adalat, it is Section 20. Can criminal cases be dealt with by AD? Yes, through Lok Adalat. Only compoundable criminal offences can be dealt. Advantage of Lok Adalat: court fee is returned plus immediate judgment. Whether the award passed by Lok Adalat is immune from Article 22? No. An appeal will lie in case of fraud, misrepresentation or mistake of fact. Permanent Lok Adalat by Amendment of 2002. Section 22A to 22E of the Legal Service Authority Act 1987. In public utility services, you have permanent Lok Adalat. Conciliation not bound by CPC IEA under 66 of the 1996 Act, ACA Act. Conciliation proceedings follow principles of natural justice. Principles of confidentiality under Section 75 of 96 Act. Negotiation defined by Pepperdine University, USA. A communication process used to put deals together or resolve conflicts. It is a voluntary, non-binding process in which the parties have control over the outcome as well as the procedures by which they make an agreement. It is also for a wide range of possible solutions, maximizing the possibility of joint gains. Negotiation nature: a bilateral mode of proceedings. Negotiation styles: cooperative style and competitive styles. Negotiation: a non-binding common communication, or the example Shimla Agreement and Lahore Declaration. You have two things, Batna and Vatna. Batna is in negotiation means best alternative to a negotiated settlement arrangement. Vatna is worst alternative to a negotiated arrangement. Negotiation will try to arrive somewhere between Batna and Vatna. Negotiation and statutes. HMA 1955 Section 23, Special Marriage Act 1954 Section 34, CPC 1908 Order 32A and Rule 3, Family Courts Act 1987 Preamble, LSA Legal Services Authority Act 1987 Section 19, the ACA 1996. Next, define mediation. It is an informal process in which a trained mediator assists the parties to jointly explore and reconcile their differences and reach a negotiated settlement. Mediation rules. Civil Mediation Rules 2003. How mediators are appointed. High Court prepares a panel of mediators. Parties can agree on appointing a mediator on their own. SC prepares a panel of mediators and will keep it on the notice board, and a copy is sent to the Bar Association. District and Sessions Judge prepares a list after approval from HC, put them on the notice board and publish a copy to the District Bar Association. Take consent of the people enlisted. The role of mediator. Mediator facilitates voluntary resolution of the dispute by parties and communicates the view of each party to the other, assists them in identifying issues, reduce the misunderstandings, clarify priorities, exploring reducing areas of compromise, and generates options in an attempt to solve the dispute. You shall not impose any terms of settlement on the parties. Time limit for mediation. Usually 60 days from the date of first appearance till the proceedings end or terminates. It need further 30 days if necessity arises. Settlement of agreement is called mediation settlement agreement. Mediation settlement agreement. Two models of mediation are there: interest-based mediation, rights-based mediation. Mediator acts as a catalyst and indicates the parties to agreement and induces the parties to reach an agreement. Various styles of mediation: facilitative approach and evaluative approach. Practical applications of mediation. One, in commercial disputes, in medical practice, mediation in bankruptcy. Who can apply for arbitration and duties of an arbitrator? Who can award arbitration to set aside under Section 30 under Section 34? If the party making an application can prove that he was under incapacity at the time of arbitration agreement is not valid. Party has not been given proper notice, that is regarding constitution of the arbitral tribunal or proceedings, then it is not valid. The composition of the tribunal not according to the agreement, then also the arbitration will fail. Subject matter is not capable of being settled through arbitration if the award is against the public policy of India. Finally, termination of arbitration proceedings. When final award is made, if the claimant withdraws his claim, if the parties agree for the termination, if the tribunal feels continuation is unnecessary or impossible, then you have termination of arbitral proceedings. Unilateral arbitration. UN Common on international trade law. What are the important documents to be submitted in arbitration? Important documents by way of affidavit should be submitted to an arbitration. Afcon's case. The trial court did not adapt the proper procedure while enforcing Section 89 of CPC. Failure to invoke Section 89 suo motu after completion of the pleadings and considering it only after the application under Section 89 was filed was erroneous. A civil court exercising power under Section 89 CPC cannot refer a suit to arbitration only unless all the parties to the suit agree to such a reference. You have to give all the 5 options. Order of trial court referring the matter to arbitration and order affirming it is set aside. The trial court shall now consider and decide upon a non-adjudicatory ADR process in mediation, conciliation or judicial settlement or Lok Adalat. Then summarize the procedure to be adopted by a court under Section 89 under the Code. When the pleadings are complete, before framing issues, the court shall fix a preliminary hearing for appearance of parties. The court shall acquaint itself with the facts of the case and the nature of the dispute between the parties. The court should first consider whether the case falls under any of the category of cases which are required to be tried by courts and not fit to be referred to any ADR process. If it finally the case falls under any of the excluded category, it should record a brief order referring to the nature of the case and why it is not fit for reference to ADR process. It will then proceed with the framing of issues and trial. In other cases, that is in cases which can be referred to ADR, the court should explain the choice of 5 ADR processes to the parties to enable them to exercise their option. The court should first ascertain whether the parties are willing for arbitration. The court should inform the parties that arbitration is an adjudicatory process by a chosen private forum and the reference to arbitration will permanently take the suit outside the ambit of the court. The parties should also be informed that the cost of arbitration will have to be borne by them. Only if the both parties agree for arbitration and also agree upon the arbitration cost, the matter should be referred to arbitration. If parties are not acceptable for arbitration, the court should ascertain whether the parties are agreeable for reference to conciliation, which will be governed by the provisions of ACA Act. If all the parties agree for reference to conciliation and agree upon the conciliator, the court has to refer the matter to conciliation under Section 64 of the ACA. If parties are not agreeable for arbitration or conciliation, which is likely to happen in most of the cases for want of consensus, the court should, keeping in mind view the preference of the options of the parties, refer the matter to any one of the 3 ADR processes. It is Lok Adalat, mediation by a neutral third party, and a judicial settlement, a judge-assisted settlement. If the court is simple, which may be complicated in a simple sitting, completed in a single sitting, or cases relating to the matter where the legal principles are clearly settled and there is no personal animosity between the parties, the court may refer the matter to Lok Adalat. In case where the questions are complicated, that is cases which may require several rounds of negotiation, the court may refer the matter to mediation. Where the facility of mediation is not available or when the parties opt for guidance of a judge to arrive at a settlement, that is very, very exceptional cases, the court may refer the matter to another judge for attempting a settlement. If a reference to ADR process fails on receipt of the report of ADR forum, the court shall proceed with hearing of the suit. If there is a settlement, the court shall examine the settlement and make a decree in terms of it, keeping the principles of Order 23, Rule 3 of the Code in mind. If the settlement includes disputes which are not the subject matter of the suit, the court may direct that the same will be governed by Section 74 of the ACA Act, that is Conciliation Settlement. And under Section 21 of the LSA Act, if it is Lok Adalat settlement or mediation settlement, which is a deemed Lok Adalat. This will be necessary as many settlement agreements deal with not only the disputes which are the subject matter of the suit or proceeding in which the reference is made, but also other disputes which are not the subject matter of the suit. If any term of the settlement is ex facie illegal or unenforceable, the court should draw the attention of the parties thereto to avoid further litigation and disputes about executability. The court should also bear in mind the following consequential aspects which giving effect to the Section 89 of the Code. If the reference is to arbitration or conciliation, the court has to record that reference is by mutual consent. Nothing further need to be stated in the order sheet. If the reference is to any other ADR process, the court should briefly record that having regard to the nature of the dispute, the case deserves to be referred to Lok Adalat or mediation or judicial settlement. There is no need for elaborate order for making the reference. The requirement under Section 89(1) that the court should formulate or reformulate the terms of settlement would only mean that the court has to briefly refer to the nature of the dispute and decide upon the appropriate ADR process. If the judge in charge of the case assists the parties and if the settlement negotiations fail, he should not deal with the adjudication of the matter to avoid apprehension of bias and prejudice. It is therefore advisable to refer the cases proposed for judicial settlement to another non-dealing judge. If the court refers the matter to an ADR process, that is non-arbitration, he should keep track of the matter by fixing a date of hearing for ADR report. The period allotted for ADR process varies from a week to 2 months, extraordinary exception depending upon the availability of the forum. Under no circumstances, the court should allow the ADR process to become a tool in the hands of unscrupulous litigant intent upon dragging on the proceedings. Normally, the court should not send the original record of the case when referring the matter to ADR forum. It should make available only copies of relevant papers to ADR forum. When pleadings are fixed, court may insist on the extra copy. If the case is referred to the court annexed mediation center, which is under exclusive control and supervision of a judicial officer, the original file may be made available when necessary. So that's it.